Thank you, Team Taxman, for giving me this opportunity to present before everyone on the issue in relation to the tax losses at a time of business restructuring. And thank you all the people present here for sparing time on this working day in the evening to be part of this session. So what I'll do is I'll just share my screen and so is I am hoping that everyone is able to see my screen, and probably then we can start. Go ahead. So let us now start. Now, I'll straight away because right now it's almost 5:05, and we have roughly 60 minutes in our hand to discuss about some of the issues in relation to the treatment of losses in case of corporate restructuring. Now, before going into what kind of restructurings possibly can happen and what are the various treatments of the tax losses, first we must understand that tax losses are very, very important in any corporate restructuring. And in case of any restructuring, the endeavor is always to protect the tax losses so that the cost to the entity, the buyer can fetch a better rate in terms of because the buyer who would be purchasing that particular entity or who would be the resultant entity out of the corporate restructuring, that person or that entity should have enough leverage in terms of the losses available, if at all there are, so that they can be utilized. So preserving of the or protecting the tax losses are very, very important. So what it does is it helps in reducing the cost. It helps, so whenever you are protecting the carry forward and set off of losses, one can significantly reduce the tax burden of the acquiring or the resulting company. In case of even third party transactions, the effective cost can get reduced of a particular transaction. And then it also helps at the time of any restructuring, at the time of any economic challenge. So there are various advantages of protecting the tax losses in case of any restructuring. Now, what are the critical conditions, considerations which are to be taken into account? One is that there has should be proper planning of the set off of losses so that it can have a direct impact on the tax outflows. It can help in preventing the tax outflows, and there are no cash flows issues. Then the other consideration is that one has to look at the relevant provisions of the income tax law which are in place, and we will be discussing about those provisions. The third and the important aspect is that one also needs to understand the checks and balances which have been put in place by the income tax, by the government under the Income Tax Act itself, in terms of any specific anti-avoidance rules, so that what are the conditions which are required to be fulfilled. So these all form part of SAR, and so one has to take care of these SAR provisions, and at the same time one has to avoid any colorable device being adopted in terms of setting off the tax losses, so that the GAAR provisions, the general anti-avoidance rules provisions, are not invoked. So GAAR and SAR can play a very important role in terms of deciding all the restructuring aspects, and also in terms of whether the set of those tax losses would be available or not. Now, all these things, as we understand, this helps in building a business value proposition. It helps in ensuring continuity of the business during financial hardships. It helps in facilitating internal restructuring and third-party transactions, and in fact, it helps in enabling growth through mergers and acquisitions. So, these are just the advantages which I've highlighted and the considerations which one has to look at whenever any business restructuring is to take place. And today we will be only discussing, or we will be only focusing on the tax losses, the set off and carry forward provisions under the Income Tax Act in case of certain restructuring transactions. Now, these are some of the typical restructuring transactions which can take place. So one can be a asset sale. There can be a direct asset sale wherein the entire asset is cherry picked and sold to a particular entity by a particular seller. Then there can be a slump sale or a business transfer agreement. So there can be entire undertaking being sold on as is basis by way of slump sale. Then the third type of transaction could be that there can be a sale of shares in a particular entity. So I am holding certain shares in a particular entity, and those shares are sold by me to a particular person who's wanting to buy the business. So sale of shares can be another mode of restructuring. Then amalgamation and merger. So we all know that restructuring, if any group wants to restructure itself, then amalgamation merger is something it always looks forward to. So amalgamation merger is when one or more companies amalgamate or merge into a particular entity. Then it is amalgamation merger. So there is amalgamation merger, also a type of restructuring. Then there's demerger, when a particular entity does not want to get into a slum sale arrangement, and there is a identified undertaking, and it wants to then hive off that undertaking into a separate company. So then the demerger can also take place. Then restructuring also happens in partnership firms in terms of the reconstitution of the partnership firm, wherein the partners are retired, wherein new partners are admitted into the partnership firm. So that kind of restructuring also happens in partnership firms. And then there is always succession or conversion of a partnership firm into a company, or a conversion of a company into a LLP. So either a firm can be converted into a company, a firm can be succeeded by a company, and it can also be other way around, that a company can also be converted into a limited liability partnership firm. Now, with these different types of transactions or restructurings which can take place, one needs to understand that what are the provisions which are applicable or which are available under the income tax law, which govern the set off and carry forward of losses in these types of restructuring transactions. So what we'll do is we'll take it one by one, and I will try and give you an overview of what are the different provisions which are applicable, and how we should go about it. Now, the first and the simplest of them all is a clear-cut sale transaction, wherein the assets are sold, and wherein the assets are cherry-picked, and separate transactions are done for different assets, and assets are sold by the seller to the buyer. And at the same time, there can also be a business transfer agreement wherein the entire undertaking or a particular part of the undertaking or an entire undertaking, so to speak, is then transferred by way of slum sale. Now, what happens in those cases? So, essentially, whenever there is a sale of an asset or a slum sale transaction happening, then essentially there is no carry forward or set of losses which is available to the purchaser. So, whosoever is the buyer is only entitled to purchase the goods, purchase the assets, or maybe in case of a slum sale, a combination of assets and liabilities of that undertaking. However, there is no losses which are transferred. So the losses typically remains with the seller only, and the losses, the benefit of those losses are not passed on to the buyer. Now, while the acquirer would have a tax shield because tax shield of higher depreciation. So one is that whenever any asset is purchased, so there is a higher the whatever cost of acquisition is that of that asset, the depreciation can be claimed by the buyer on that particular asset. So essentially, there'll be a benefit of higher depreciation which can be charged by the buyer. Then, as far as the losses, as I've already mentioned, the losses remain with the seller only, and even the MAT credit is not passed on to the not passed on to the buyer, and it remains with the seller itself. Then whatever losses are available in the with the company who's transferring the assets, they remain with the company, and those losses can be set off for a set off for against for 8 assessment years for whatever income is generated out of that business. Even the depreciation which has remained unabsorbed can be set off. So essentially, unlike in case of a merger or an amalgamation, the all the benefits of the losses and the unabsorbed depreciation remain with the seller only. The buyer only gets the advantage of of the depreciation which he can claim on the assets going forward once he has purchased those assets. Normally, what happens is that there is no requirement for continuity of business in case of a slum sale or an asset sale, because these are the requirements which are there in case of an amalgamation. If when a company is amalgamating, then we'll discuss that there is a requirement for continuity of business, but there is no such requirement for continuity in case of a asset sale or a slum sale. Now, next, so this tax losses in case of asset sale and slum sale is quite a plain vanilla thing. You don't have to, you don't have to, you don't have to consider. You don't have to work on the losses which the seller is having. The losses and the depreciation remain with the seller. Now, the second is that when there is a change in the shareholding, when the shares are transferred by the shareholders and there is a change in shareholding for the company. Now, in that case, there is section 79, which is very important and one which one must consider. The section 79 is typically applicable on companies which are closely held companies, the companies in which public are not substantially interested. Now, the section 79 starts with a non-obstant clause. So it will have the section 79 is on a higher footing in terms of other sections in the particular chapter of carry forward, brought forward losses. So in that scenario, Section 79, which is at a higher pedestal, even if the losses are available, then if there is a change in shareholding, then because of Section 79, there cannot be any carry forward and set off of losses if the conditions as prescribed therein are not fulfilled. Now, what are the conditions? The condition is that, so first of all, as I've already mentioned, that this Section 79 is only applicable in case of a closely held company, the company in which public are not substantially interested. Now, what do you mean by company in which public are not substantially interested? Essentially, what is there is that the companies in which public are substantially interested, this is defined under the income tax law. And if one looks at Section 2, Clause 18, it defines it has a specific definition which states that what all companies are covered in which a public are substantially interested. So if a particular company, like a private limited company, which is not a 100% subsidiary of any other public company or a listed company, then in that scenario, that particular company would be a company in which public are not substantially interested. Now, only in those companies, Section 79 would be applicable. Now, one question that arises is when it is to be seen. So, because there are other conditions, the other condition is that whenever there is a loss, then in that scenario, the loss will only one can carry forward the losses only when 51% of the shareholding remains the same. If one is to consider the year in which the loss arises and the year in which the loss is set off. So the wordings of this section is that no loss incurred in any year prior to the previous year shall be carried forward and set off against the income of the previous year unless on the last day of the previous year. So it has to be seen on the last day of the previous year in which the loss arises and the last day of the previous year in which the loss is set off. Those two dates are to be seen, and if the shareholding is more than the 51% shareholding remains the same, then in such a scenario, the carry forward and set off of losses is allowed. If the change in shareholding is such that the 51% shareholding does not remain the same, then in such a scenario, there would not be any the carry forward and set off of losses would not be applicable. So although the carry forward and set off of losses are allowed for a period of 8 years, but in that period of 8 years, if there is such change in the shareholding, then Section 79 will come into the picture and will block the carry forward and set off of losses. Now, there are two, three aspects which we must understand in this is that what is the point of time when the status of the company will have to be considered? Because as I mentioned, Section 79 is only applicable in case of a closely held company or a company in which public are not substantially interested. Now, when is the status to be seen? Then, so the status is to be seen when there is a change in the shareholding or when the change in the shareholding pattern takes place. That is the point of time it is relevant to determine the applicability of Section 79, and that is the time one is to see whether this particular company falls under the definition of 218, which is in those whether in that company public are substantially interested or not. And if it is not so, then only Section 79 would be applicable. Otherwise, if the company falls under Section 2 Clause 18, which is a company in which public are substantially interested, then the carry forward and set off of losses can take place even if there is a change in the shareholding more than 51%. Now, the second important aspect is that this section talks about beneficial ownership of the shares. So it says that the not less than 51% of the voting power are beneficially held by persons who beneficially held by persons who beneficially held shares of the company carrying not less than 51%. Now the issue is, it talks about beneficial ownership. So what will prevail? Whether a beneficial ownership would prevail, or whether a registered ownership would be relevant for this set off. Now the issue is, so there are certain questions in the Q&A box. I'll take it once I'll finish all the major issues, and then we'll take it up at the end. So one issue is that whether it is beneficial ownership is to be seen, or the registered ownership is to be seen. So there are both the views available. Some of the decisions which have come up have said that since the word used in section 79 is that the share should be beneficially held, then in such a scenario the beneficial ownership should be seen, and if the beneficial ownership remains intact, then the carry forward and set of losses is preserved. However, there is another view also that when in certain cases wherein the accumulated losses were denied for change in the registered ownership, even though the beneficial ownership had remained the same. So however, my view is that we can go with the view number one, wherein because it has been specifically mentioned that the beneficial ownership would be important, then one may take a view that the beneficial ownership is something which one would want to ascertain for section 79. Now, there are other aspects. Section 79 only talks about the set off carry forward and set off of losses. It does not talk about depreciation. So, when there is depreciation, unabsorbed depreciation, then that depreciation can also be carried forward and set off, even if there is change in the shareholding, and even if the conditions as prescribed in section 79 that we have discussed of 51% shareholding remaining the same are not fulfilled. So because the section 79 expressly talks about only the losses, and it does not talk about unabsorbed depreciation. So essentially, there is no embargo of any sort in terms of claiming the unabsorbed depreciation whenever there is a change in the shareholding of the company. And in this, one can refer to a Supreme Court decision in the case of Sri Shubhu Lakshmi Mills Limited, wherein it has been mentioned that Section 79 does not talk about depreciation, it does not cover depreciation. Accordingly, one may carry forward and set off unabsorbed depreciation even in case of change in the shareholding. Now, the next issue in section 79 itself is that section 79, there was a proviso which was inserted to the subsection 1, which states that whenever there is an eligible startup, in case of eligible startups, even if there is change in shareholding, then also the section 79 benefit would be available. And so it refers to the eligible startup. Eligible startup is defined under section 80 IAC, and there are conditions prescribed for any startup to be considered as a eligible startup, and that is there very much there in section 80 IAC. And some of the conditions, if you look at, so essentially there are three conditions. One is that it should be incorporated on or after 1st of April 2016, but before the first day of April 2025. That is the first condition. Second condition is that the turnover should not be more than 100 crores. And the third and important condition is that it should hold a certificate of eligible business from an interministerial board of certification. So essentially, from a DPIIT, there has to be a certificate, and specifically for 80 IAC, a certification or a approval must be received by the particular entity from the income tax department. Now, in if the particular entity fulfills these conditions, then it will fall in the definition of eligible startup. And if it falls under the definition of eligible startups, then in such a scenario, even if there is change in the shareholding, then there would not be any applicability, or there would not be any embargo which could be created in terms of Section 79. And then also the company or the entity or the eligible startup would be able to carry forward and set off his losses. However, one important aspect which one must understand is that one requirement is that all the shareholders, so there is no requirement of 51% shareholding being the same, but there is a requirement that all the shareholders of the company who have held the shares at the time when the losses had arisen, and at the time when the loss set off is made, then all the shareholders should be there with the company. So essentially, what it requires is that the promoters or the initial shareholders which were there with the company, that should remain the same, and that should be carried forward, or that they should remain with the company even if a new investor has come in, and that investor has infused so much of money that the original shareholders shares shareholding in the company has reduced by even 51%. However, it is important that all the shareholders should be available or should be there at the time when the set off is taking place, as they were when the loss had arisen. Now, it does not talk about inter se percentage of the shareholding, even if there is change in the inter se shareholding percentage of the original shareholders, then also, since the condition of all the shareholders is fulfilled, then in such a scenario, Section 79 applicability would not be there, and the company would be able to set off its losses. Now, next we come to, so this was all about carry forward and set off of losses in certain cases wherein there is change in the shareholding. As I mentioned, this is only applicable in case of a company which is a closely held company and in which public are not substantially interested. In case if there is a company in which public are substantially interested, then in such a scenario, the losses can be carried forward without any embargo being placed of Section 79. Now we come to another important section, that is Section 72A. Now, whenever there is, as I mentioned in the earlier part, whenever there is what are the options of when we talk about the options of restructuring? One option is that one entity may merge itself with another entity, and the second option is that there may be a demerger by a NCLT approved scheme of arrangement. So there can be a demerger. Now, in such a scenario, how would the tax losses, what would be the treatment of the tax losses is important to understand. And for that, the relevant section under the income tax law is Section 72 capital A. Now, Section 72 capital A is applicable on losses as well as on unabsorbed depreciation. Unlike 79, as I mentioned earlier, also that the Section 79 is only applicable on losses and not applicable on unabsorbed depreciation. However, Section 72 capital A is applicable on carry forward and set off of accumulated losses and unabsorbed depreciation, both in a scenario wherein there is amalgamation or demerger taking place. Now, what are the conditions which are required to be fulfilled? We will be discussing that. First condition is which is there under Section 72 capital A, that the amalgamating company should be an industrial undertaking. Now, first is that the entity which is amalgamating should be an industrial undertaking. Now, what do you mean by industrial? So there are other conditions also, that the amalgamating company should either be an industrial undertaking, or should be a ship or a hotel, in the business of shipping or hotel, or a banking company, or any public sector company. So I'm not discussing about public sector or banking company. I'm focusing on the companies which are can be considered as an industrial undertaking. Now, industrial undertaking has also been defined under Section 72 capital A. 72 capital A subsection 7 defines what do you mean by industrial undertaking, and it includes all the undertakings which are engaged in manufacturing and processing of goods, computer software, a business of generation, distribution of electricity, telecom, mining, construction of ships, aircraft, or rail systems. So all these are included as part of a business undertaking, industrial undertaking. Now, when we talk about manufacturing or processing of goods, so manufacturing, the meaning has been interpreted widely by the Supreme Court. There are various case laws to that effect as to under what scenario what would be considered as manufacturing. For instance, in case of Aryan Tiles and Marbles Private Limited, Supreme Court held that conversion of a marble block into slabs would also be considered as manufacturing, or for that matter, bottling of gas into cylinder for domestic use would be considered as manufacturing. However, cutting and polishing of diamonds would not be considered as manufacturing. So one needs to understand that whether the processes or the activities which are taken, considered or undertaken by a particular company, whether that would qualify as a manufacturing activity, and in turn would be considered as an industrial undertaking. That is very important to understand. Now, there what all is not included. So, whosoever is in the service sector, that is not included. So, for example, if a company is into a logistics business, or the company is into advisory business, or in financial services, or even non-banking finance companies, these are not included as part of undertaking. Even hospitals are not considered as an industrial undertaking. So this is quite surprising, because earlier when these sections were introduced, there was no service sector which was that much prevalent in our country. But now the contribution of service sector is almost more than 50% to the India and to the country's GDP, and essentially there are no specific sections through which the carry forward the losses of a service sector entity may be engaged in logistics or advisory or financial services, or for that matter NBFC, can be carried forward. So first condition is that it has to be an industrial undertaking. Now, before that, one also needs to understand that Section 72 capital A starts with when there is an amalgamation. Now, amalgamation is also defined under the income tax law. Amalgamation, when we look at the Section 2 Clause 1B, amalgamation has been defined. Defined under the income tax law, and whenever one has to look at the applicability of Section 72A, one will have to first look at the definition of amalgamation, and has to first identify whether a particular amalgamation taking place falls in the definition of amalgamation as provided in the act. And if that is fulfilled, then only then only Section 79 benefit, 72 capital A benefit can be taken by the amalgamated entity. So amalgamation, the conditions have to be fulfilled. Now, there is always a scenario wherein, because of the amalgamation, there can be a substantial change in the shareholding of the amalgamating, or in case of a demerger, a demerged company. Now, what happens if there, because of that amalgamation or a demerger, 51% shareholding has changed, and as a result of which, the shareholders, 51% shareholders, have not remained the same. Now the question arises whether section 79 would come into the picture. So essentially, one is fulfilling the conditions as prescribed under section 72 capital A. However, if the shareholding has changed, and if that particular company, if one assumes is not a company in which public are substantially interested, it's a closely held company of whose amalgamation is taking place, then whether section 72 capital A would prevail, or whether section 79 would prevail. And can it be said that even though the conditions as prescribed under section 72 capital A are fulfilled, however, since section 79 is also there, then section 79 conditions would be at a higher pedestal than section 72A. Now, in this, one needs to understand that Section 79 also starts with a non-obstant clause. It says that notwithstanding anything contained in that particular chapter, and that chapter is related to carry forward and set off of losses. Now, notwithstanding anything contained in that particular chapter. Now, can it be said that Section 72A will not be prevailing over 79? Now, the question is that one also has to look at Section 72A subsection 1 and subsection 4, and one can argue that these are all specific sections for carry forward and set off of accumulated losses and unabsorbed depreciation, and these specifically deal with merger and amalgamation demerger cases. And in such a scenario, when there is a specific section already available, then the specific section would prevail over section 79. So so the better view, and I am also of the view that, say, whenever there is a conflict between section 72 capital A and section 79, section 72 capital A would always prevail, because because the subsections used therein are specific to a particular transaction and not general in nature. And when there is a conflict between a specific section and general section, then always a specific section would prevail over the general section. Now, next issue is that in case of a merger or amalgamation or a demerger, Section 72A specifically talks about accumulated business losses and unabsorbed depreciation. Whenever there are losses under the head capital gains, then those losses essentially one will not be able to set it off, and no one will not be able to set it off and carry forward under the head capital gain. So the benefit of set off and carry forward of losses under that capital gains would not be available to a transferee company. And this, for this, there is a specific section, there is a specific case law, which is Clarient Chemicals 53 taxman.com 39. Even otherwise, if one looks at the section 72A properly, then in such a scenario, one may able to gauge that the section 72A only talks about accumulated business losses and unabsorbed depreciation. It does not anywhere talk about losses under the head capital gains. Now, Section 72, as I mentioned, is also a specific anti-avoidance rule. So it has got certain checks and balances with it, wherein if any conditions of the amalgamating or the amalgamated company which are prescribed therein are not fulfilled, then Section 72A benefit would not be available to that particular entity for the what. So what are now the questions? What are the conditions which are prescribed for the amalgamating and the amalgamated company? These are all in subsection 2 of section 79, 72 capital A. Now there are conditions, specific conditions for the amalgamating company and specific conditions for the amalgamated company. First, we talk about the amalgamating company. The condition is that should the amalgamating company should be engaged in the business in which the accumulated loss occurred or depreciation remains unabsorbed for at least 3 years prior to the amalgamation. So, condition prior to amalgamation is that it should be engaged in the same business which is 3 years prior to the amalgamation taking place, and the amalgamating company should have continuously held three-fourth of the value of the fixed assets for at least 2 years prior to the date of amalgamation. So these are the two conditions which are required to be fulfilled. Now, should be engaged in the business. So the query has been raised that the words used therein are has been engaged in the business. So if you look at the condition, it says that has been engaged in the business in which accumulated loss occurred and depreciation remains unabsorbed. So, if there are two streams of businesses and clearly identifiable businesses, and if one business is stopped, and then in such a scenario, the entity will not be able to take the benefit of this business, and presumably the loss has occurred in that particular business which has stopped. Then such a scenario, section 72A benefit would not be available. Then for there are conditions which are for the amalgamated company as well. Upon merger, it is required to hold three-fourth of the fixed assets in business of the amalgamating company for a period of 5 years. The three-fourth of the fixed assets and the business should be with the amalgamating company for a minimum period of 5 years, and not before 5 years they can do away with the business or the fixed assets. And the production capacity should be at least 50% of the installed capacity within 4 years of the amalgamation, and should continue to maintain up to 5 years from amalgamation. So this capacity also the threshold has to be achieved. And even if in the first 3 years it is not there, and if the fourth year it is maintained, then also it is fine. So it has to be within the bracket of 4 years and not in all the 4 years. So that is important, one needs to understand. Now, if those conditions are fulfilled, then for a period of 8 years, the set off and carry forward of losses would be available for the with the amalgamating company which are belonging to the amalgamated company. So for the period of 8 years, one will be able to take the benefit. Now, if the above conditions are not fulfilled, if at all, once the amalgamation has taken place and the conditions are not fulfilled, then in the year of default, whatever benefit has been taken in the year of default, the same amount would be taxable in the hands of the amalgamated company. Now, similar are the requirements in case of demerger. Now, demerger is also defined under the income tax law. If one looks at section 2, clause 19 double A of the Income Tax Act, then the demerger is defined. I am not getting into the details of it, but one important rule is that the demerger, a particular transaction would be considered as a demerger when the undertaking test is fulfilled. So the particular undertaking should be able to work on its own, and then only it would be considered as a demerger. And in such a scenario, section 72 capital A would be applicable. Now, in such a scenario, so what in the transfer, so the other conditions which are available are that the undertaking should be transferred, all the assets and liabilities of the undertaking must be transferred to the resulting company, which normally happens, and there should be business continuity. There should be a running business capable of operations uninterruptedly whenever the assets and liabilities have been transferred. Now, in such a scenario, if all these conditions are fulfilled, then the losses, the accumulated losses, as well as the unabsorbed depreciation are allowed to be carried forward and set off by the resulting company. Now, the question arises whether it is for the 8-year period for the resulting company or for the remaining period. The answer is that it has to be utilized for the remaining period only, and a fresh 8-year period start would not be given in case of a demerger. Now, whenever there is an undertaking and there may be a scenario that there are since there are more, there can be more than one undertaking, which normally is the scenario, then how is the losses and unabsorbed depreciation are required to be apportioned? So if the loss or unabsorbed depreciation directly relates to the undertaking which is transferred, then as it is, the accumulated losses and unabsorbed depreciation would be allowed to be carried forward in the carried forward in the resulting company. However, if they are not directly relatable, then one will have to apportion the losses and unabsorbed depreciation between the assets which are held by the which are retained by the demerged entity and which are transferred by the resulting company, transferred to the resulting company. Now, the question arises that the apportionment will be on a net basis or on a gross basis. So there has to be some basis. So the law is very silent, but there has to be some basis in terms of apportioning that amount. Probably on net basis would be something which would be easier for the entities to apportion the amount. So the apportionment has to be there when it is not directly relatable to the undertaking which is transferred. Secondly, the as I already mentioned, the resulting company would be able to utilize the brought forward losses and unabsorbed depreciation for the balance number of years for which the demerged entity would have carried forward. So had the demerger not taken place. So in case of an amalgamation, 8-year fresh start is given, but in case of a demerger, the period up to which the demerged entity would have carried forward the unabsorbed the accumulated losses and unabsorbed depreciation, to that extent only it is possible. Now, one important aspect which one clearly needs to give a lot of weightage to is that there can be an applicability of general anti-avoidance rules in case of a particular transaction. Now, essentially, GAAR kicks in when there are no commercial substance to a particular transaction, and if it is seen by the tax authorities that the transaction or the amalgamation or merger or demerger has taken place essentially to take a tax benefit, and that has been the sole motive of getting into a particular transaction and not the actual, and there is no other rationale behind this particular transaction. Now, in such a scenario, GAAR can be invoked. So whenever the scheme documents are being drafted, one needs to take care of the fact that a proper rationale should be given, so that tomorrow the tax authorities cannot say that the entire transaction had been so arranged just to take the tax benefit. That should not be there. So always a commercial motive should be available with the entities, and if the commercial motive is not available, and if it is seen that the transactions have been done in a way that so as to get the advantage of the tax, so as to get the tax benefit or to reduce the taxes, then even if Section 72A conditions are fulfilled, then also the GAAR can kick in and can consider can ignore the entire arrangement which has been entered between the entities, and take whatever recover the tax amount from if the transaction would not have taken place. Now, there is also a circular related to GAAR in CBDT circular at question number 8. It states that wherein NCLT has explicitly and adequately considered the tax implications while sanctioning the arrangement, GAAR will not apply. However, practically, it is very difficult because there are less number of cases wherein at the stage of approval from the NCLT, the NCLT looks at explicitly and adequately the tax implications. Normally, and there have been Supreme Court decisions also that at least at the stage of approving the scheme, the courts are not required to go into the tax implication that has to be seen in regular assessment proceedings. So normally this situation does not arise wherein NCLT in its order considers the tax implications of a particular transaction. So the nutshell is that the commercial rationale of entering into any particular transaction is very, very important. Without a commercial rationale, it might get difficult for the taxpayers or for the entities to convince the tax authorities that the motive was not only to take the tax benefit, but also to align it with the whatever thinking the management of the company is having behind the business, or with the different structures within the entity. Now, there is also one more aspect whenever there is a capital loss. So, essentially, a long-term capital loss can be set off only against long-term capital gain, and unadjusted long-term capital loss can be carried forward up to 8 succeeding years. Now, in such a scenario, if again, if there is no commercial rationale, and if it is seen that the losses, the transaction had been undertaken just to set off the losses, then again there can be implication under GAAR. Even if the GAAR thresholds are not met, then also if it is considered, it can be considered as a colorable device, and there are judgments to this effect. McDowell's Supreme Court decision says that even there are colorable device, then the income tax department has the power to ignore that particular structure, that particular transaction. So even if GAAR thresholds are not met, then also one should consider whether there is any commercial rationale, or whether it is just the transactions are being designed in such a manner that the losses are being set off against the profits. Now we come to the last part of our discussion, and probably thereafter we can take up the then we can take up the questions. There are certain questions in the Q&A box and also in the chat box. The last part is that in case of reconstitution or conversion of firms, reconstitution, a partnership firm, or a conversion of a firm into company, or a company into LLP, then in that case, can losses be carried forward into the resultant entity? The answer is, first, let us talk about conversion of a firm into a company, or vice versa. Whenever a firm is converted into a company, then one will then essentially it is considered as a transfer. Of course, there are decisions to that effect, but uh, the if the conditions as prescribed under Section 47, Clause 13, if these are fulfilled, then it is not considered as a transfer. Now the same conditions have been borrowed for the loss for the set off of losses in case of section 72 capital A as well. And there is subsection 6 which says that whenever there is a conversion of a firm or a LLP into a company, and if there are losses in the firm or the LLP, then such losses or unabsorbed depreciation can be carried forward only in a scenario wherein the conditions which are there under clause 13 of section 47, if those are fulfilled, then only this carry forward of business losses and unabsorbed depreciation is possible. Now, if these conditions are not fulfilled, then the carry forward of business losses and unabsorbed depreciation is not possible. Similar is the scenario in case of a conversion of a company into a limited liability partnership firm. As we all know, a company can also be converted into a limited liability partnership firm, and to that effect, there is section 47, clause 13b, which sets out the conditions which are to be fulfilled for a conversion from a company into LLP not being considered as a transfer. And those conditions have, for the purpose of 72 capital A, also been borrowed from section 4713b. And if in case there are business losses or an absorbed depreciation in a company, those cannot be carried forward in the successor entity, that is LLP, if the conditions as prescribed under section 4713b are not fulfilled. If these are fulfilled, then only the carry forward of accumulated business losses and unabsorbed depreciation is possible. Otherwise, it is not possible. One may refer to a celerity to Mumbai Tribunal decision in the case of Celerity Power also, 100 taxman.com 129, wherein in this case the conditions as prescribed under section 4713 were not fulfilled, and resultantly what had happened was that the losses which were in the company were denied to be carried forward into the LLP. Now, so this is about conversion from a firm or LLP to a company and company to LLP, and how the losses can be carried forward, the carried forward and unabsorbed depreciation can be carried forward. In case of reconstitution of a partnership firm, what happens is when there is a retirement of a partner or a death of a partner, and there is a reconstitution of a partnership firm on account of that. Now, in that scenario, one needs to refer to section 78, and section 78 says that whenever, because section 78 subsection 1 is only applicable in such a scenario, and if one looks at section 78 subsection 1, it says that whenever there is a change in the constitution of the partnership firm, and the change is on account of retirement or a death of the partner, then the reconstituted firm shall not be eligible to carry forward and set off the losses which are proportionate to the share of the retired or the deceased partner as exceeds his share of profit. So if there is if it is not proportionate to the share of profit, then the reconstituted firm will not be able to carry forward and set off the losses. So one will have to look at section 78 also whenever there is any reconstitution which is taking place. So essentially what happens is that the share of loss is attributable to the outgoing partner would lapse in the hands of the firm and is not eligible to be set off against the future profits. Now, one way can be that you don't retire a particular partner. Of course, in death, it is unavoidable, but in case of retirement, if there are losses, so one way out can be that one can reduce one should not completely retire the partner, but one can reduce the percentage profit sharing ratio of that particular partner maybe to a very minuscule percentage, and still can get the benefit. But again, if the motive is just to take claim the tax benefit, then even GAAR provisions can kick in, as I've been mentioning throughout. Then in such a scenario, also GAAR provisions can be may kick in. So the essential part is that one will have to first understand the rationale or make out a case of a business rationale why this particular partner has not been retired and the profit sharing ratio has reduced. And however, if it comes to the knowledge of the income tax department that the entire reduction, the retirement, although he is retired, the partner is retired, but it has been arranged in such a manner that his percentage has been reduced to a greater extent so that the losses can be carried forward. Then in such a scenario, GAAR provisions can kick in, or even if the threshold is not met, then the tax department can even apply the Supreme Court decision, which are there in the case of McDowell's and other decisions, for avoiding any colorable devices. So these are all the different provisions which I wanted to discuss. Now, let us take some of the questions which have come in the chat box. Let us start from the beginning. In the case of slump sale, can the transferee claim depreciation on goodwill difference between book value and consideration? Essentially, in after the amendment, probably this would not be possible because if there is a goodwill which has been purchased, then only depreciation would be possible. Otherwise, in my view, it won't be possible. At which level change in shareholding for the purpose of Section 79 needs to be seen evaluated, that is at the immediate parent level or ultimate parent level. See, Section 17, and as I mentioned, is applicable in case of, it also talks about beneficial shareholding. So essentially, if one has to look at the beneficial shareholding, so there have been cases to the effect that if the ultimate holding company, the shareholding has not changed, then it has stated that since the ultimate beneficiaries have remained the same, then Section 79 would not kick in. So essentially, one may even take a view that one will have to look at the ultimate parent company also and find out whether the ultimate beneficial ownership has changed or not. And if it is not changed, then one may take a view that Section 79 would not be applicable. If a private limited company, say held by say individuals, which has accumulated losses, is sold to a listed company, in such a case, will the accumulated losses be eligible? So essentially, see, at the time of transfer, one will have to look at whether it is a company in which public are substantially interested or not. And if at the time of transfer it is held by individuals, so essentially it's a closely held company, then in such a scenario, Section 79 will kick in. And even though after the transfer, the it has turned into a company in which public are substantially interested, then that will not make any difference, and still Section 79 would kick in. And one so the to answer your question, the whether the company is a company in which public are substantially interested or not has to be seen when the transfer is taking place. Are there any instances decision or loss of an Indian company got lapsed under Section 79 as there is a change in the shareholding at ultimate parent company outside India? So probably view one, I'm not aware of any direct case law in this regard, but one may find out. But essentially, one will have to find out the case law. I'm not sure whether the parent company outside India, there is any particular judicial precedence available. Now, Section 72A does not apply to services company because it only talks about industrial undertaking. So essentially, one cannot ascertain the capacity. There is no requirement for ascertaining the capacity of the service company because Section 72A does not apply to a service company. It only applies to a manufacturing entity or a industrial undertaking. Will engaged in business be counted from the date of incorporation when operations begin? It has to be counted from the operations. When the operations begin, then only one can take it as engaged in business. Because if the operations are not there, then the clear stream of business is not available. So once the operations begin, then only it has to be counted. So but there is no carry forward of LTCL in case of structuring right as concluded by the and then how is question of evading? See, I am just giving an example that if a transaction is being done in such a way, and if it comes to the knowledge that there is a loss and there is a profit, just to set off the two, then there can be a scenario of GAAR being applicable, otherwise not. So I'm not making a general statement, and it has to be quite fact specific. But my only concern was that this should be brought to the notice of everyone so that if one is trying to manage the transaction in such a manner that both of them get set off and the income tax department comes to know of this, then GAAR can even be invoked in this. What would be the implication of conversion of a proprietorship to private company? So proprietorship to private company, it will not be possible. The set off will, the carry forward and set off will not be possible in such a scenario. In case of transfer company in the tax rate of 22% and the transfer company is in the tax rate of 15%, and transfer company continue to take benefit of 15% after merger. So essentially, it should not be such that it is something which is because under 115 BAB, it says that the arrangement should not be splitting up or reconstruction. So if that is there, then it would be difficult. Otherwise, I don't see any problem. In case a company is incorporated in 2020 and has started setting up machineries and applied for a license in 2020 itself, however, commercial production started in 2022, then from which year engaged in business condition will have to be checked. So essentially, what I feel is that if by the time commercial production starts, that might not be relevant if the licenses have been obtained, then it can be considered to be engaged in business. So engaged in business is not something wherein production or the first product has to come out of the manufacturing unit. It is the time when you apply for licenses and you've started your working, then it is engaged in business. There is one more question. So no depreciation can be claimed by seller on slump sale. Is that I can claim higher cost being an opening WDV of depreciation asset as no depreciation would have been charged while computing net worth of the undertaking. I'm not sure what the question is. No depreciation can be claimed by the seller on slump sale. Is that I can claim higher cost being an opening WDV on the depreciable asset while computing the net worth of the in case of slum sale, essentially the seller will not be able to take depreciation, and the buyer, depending upon the value at which it is purchased, will have to can charge depreciation. For conversion of a LLP to a PLC, new PAN is, yes, new PAN is there. Whenever any conversion happens from company to LLP or a LLP to a company, a new PAN is obtained. So, if an undertaking is not qualified as industrial undertaking, will the carry forward of loss of amalgamating company will lapse for the yes, absolutely. The industrial, it has to be, the amalgamating company has to be an industrial undertaking. Otherwise, it will get lapsed. Can I claim proportionate depreciation on slump sale based on succession? So probably that I will have to check, Sneha. I will have to check and get back to you. Probably I will have to read through the section and then only I'll be able to help you. So we're already at 6:12. So I've taken almost all the questions. Now we can conclude. Thank you so much for patiently listening to the session. I hope I've answered most of the queries, and I hope the session was useful for everyone.